Hello everyone, I'm Dr. Veena M.D. Almeida, Associate Professor, Department of Commerce, Teresian College, Mysore. Today's subject of discussion is Company Law and Practice, Unit Company Meetings. In this particular unit, we are going to learn about meaning of company meetings, types of company meetings, importance, requisites of a valid meeting, notice, quorum, resolution, voting, proxy, role of a company secretary in convening the meeting. In this particular session, we are going to learn about meaning of company meetings, importance of company meetings, requisites of a valid meeting, proper authority to convene a valid meeting, notice and quorum. Meetings are a must for every organization or association to discuss various matters and to take decisions on important issues. Meetings are required to be held by a concerned periodically. A meeting is a congregation, assembly, gathering, get together of the members of an organization at a particular place for the purpose of discussing and deciding all important matters concerning the business of their organization. For example, dividend policy of a company, appointment of a secretary, appointment of the auditors, appointment of a director, opening of a new branch, etc. Every company meeting should be validly held. If there are any irregularities in convening and conducting a meeting, the proceedings of that meeting will be invalid and consequently the decisions arrived at that meeting will not be binding. Sections 171 to 186 of the Companies Act contain provisions relating to the convening and conducting of meetings, which must be compulsorily followed by every public company and every private company which is a subsidiary of a public company. The essentials of a valid meeting as per the provisions of the Companies Act and the articles of the company concerned are: first one, the meeting must be properly convened as per the provisions of the Companies Act. A meeting is said to be properly convened only when it is convened by the proper authority and if it is convened by a proper notice. Second one, the meeting must be properly constituted. A meeting is said to be properly constituted if the requisite quorum is present at the meeting and the meeting is presided over by a person duly elected as the chairman. Third one, the meeting must be properly conducted or held. A meeting is said to be properly conducted if there is an agenda for the meeting and the items on the agenda are discussed in the order in which they are found on the agenda. And all the matters to be discussed at the meeting are properly moved and the sense of the meeting is ascertained through a proper method and the decisions are arrived at by passing resolutions, and if there is a record of the proceedings of the meeting in the minutes book. Now let us consider the various requirements or provisions of a valid meeting in detail. First one, proper authority to convene a meeting. A meeting must be convened by a proper authority, otherwise the meeting will not be a valid meeting. The proper authority to convene a general meeting of a company is the Board of Directors. The Board of Directors must convene the general meeting by passing a resolution to that effect at a validly held board meeting. It may be noted that if the board meeting itself is not validly held, then the resolution passed at the board meeting for holding the general meeting and proceedings of the general meeting will be null and void. When a requisition is made by the required number of members of a company for convening a general meeting, that is an extraordinary general meeting, the board must convene the extraordinary general meeting within 21 days of the requisition. If the board fails to convene the extraordinary general meeting, the requisitionists themselves may convene such a meeting within 45 days of the requisition. And if a company fails to call an annual general meeting, the company law board, now the tribunal, may convene an annual general meeting when an application is received from any member of the company for convening such a meeting. The second important requirement of a valid general meeting is that a proper notice of the meeting should be given to all those who are entitled to attend the meeting. Under Section 171 of the Companies Act, a general meeting of a company may be called by giving a notice of not less than 21 days in writing. It may, however, be called by giving a shorter notice. In the case of an annual general meeting of any company, if all the members entitled to attend and vote at the meeting give their consent thereto. And in the case of any other general meeting of a company having share capital, if the members holding not less than 95% of the paid up share capital of the company give their consent thereto. And in the case of any other general meeting of a company without share capital, if the members holding not less than 95% of the voting powers exercisable at the meeting give their consent thereto. In the context of the length of the notice, the 21 days mentioned in the Act mean 21 clear days. 21 days excluding the day on which the notice is issued and the day of the meeting. As per section 53, subsection 2b, the notice sent to a member is deemed to have been received by him at the expiry of 48 hours from the time of posting of the notice. The notice must specify the day, time, and place of the meeting. It must also contain a statement of the business to be transacted at the meeting. Again, if any item on the agenda requires the passing of a special resolution, it must be stated clearly in the notice. Except in the case of non-trading company, the meeting of every company must be held on a working day and during working hours unless the members agree to hold it otherwise. Again, the meeting of a company must be held at the registered office of the company or at any other place in the same city, town or village where the registered office of the company is situated. A notice of the general meeting may be given to every shareholder entitled to attend the meeting either personally or by post to his registered address. Notice to the holders of share warrants is given through an advertisement in the newspapers. This is a specimen copy of a notice of a board meeting which contains company name, time, day of the week, date in words, agenda, etc. The next requirement of a valid meeting is the presence of a quorum in the meeting. Any business transacted at a meeting without a quorum is invalid. The main purpose of the quorum is to avoid taking decisions at a meeting by a small minority of members which may be unacceptable to the vast majority of members. Quorum is the minimum number of members required to attend a meeting and transact business validly. Section 174 of the Companies Act has laid down the provisions regarding the quorum of a general meeting. Two members personally present in the case of a private company and five members personally present in the case of a public company constitute the quorum for a general meeting. A proxy cannot be considered for the quorum. Only members present can be considered for the quorum. Third one, ordinarily, in a general meeting of a company, the quorum is required to be present not only at the time of the commencement of the business, but is also required to be maintained throughout the meeting. As such, if a general meeting of a company starts with the required quorum, but the attendance falls below the required quorum, subsequently, further formal proceedings should stop as soon as the fall in quorum is pointed out. If the quorum is not present within half an hour of the scheduled time of the meeting will stand adjourned to the same day in the next week at the same time and place. Next important, if at the adjourned meeting also the quorum is not present within half an hour of the scheduled time of the meeting, the members present will form the quorum. In the case of a general meeting called by the requisitionist, if there is no quorum within half an hour of the scheduled time of the meeting stands dissolved, cancelled. In the case of a meeting held under the order of the tribunal, the quorum is determined by the tribunal. In this case, even a single member present in person or by proxy may be considered as forming the quorum. Any business transacted at the general meeting without the quorum is invalid. And joint holders of shares are to be treated as one member for the purpose of quorum. And if the business proposed to be transacted at a general meeting does not include any item or resolution proposed to be passed which directly affects the rights of the preference shareholders, their presence should not be taken into account for the purpose of the quorum. Of course, where the subject matter includes any resolution in which the rights of preference shareholders are directly affected, their presence should be taken into account for the purpose of the quorum. As per the provisions of the Companies Act, a member of the company may vote at a meeting either in person or by proxy. That means a member entitled to attend and vote at a meeting can appoint another person as his proxy to attend and vote on his behalf. The term proxy has double meaning. It refers to a person who is authorized by a member of a company to attend and vote at a meeting of the company on his behalf. It is also an instrument authorizing a person to act as a proxy of a member. Types of proxies. There are two types. First one is special proxy, second one general proxy. A special proxy is a proxy who is authorized to vote only on a particular motion or proposal. A general proxy is a person who is authorized to vote on all motions or proposals in a meeting. Proxy forms. The two forms of proxy are general proxy form or one-way proxy form, and second one is two-way proxy form. A general proxy form or one-way proxy form is one which authorizes the person appointed as a proxy to merely vote for the appointer. The general proxy form implies that the proxy should vote only in the affirmative. That is, he should vote only in favor of the motion or proposal. A two-way proxy form is one which authorizes the person appointed as a proxy to vote either for or against the motion. Section 176 of the Companies Act has laid down certain provisions relating to proxy. They are: any member of a company having share capital entitled to attend and vote at a meeting can appoint another person as his proxy to attend and vote at the meeting on his behalf. Unless the Articles of Association provide otherwise, a member of a company not having share capital cannot appoint a proxy. A member of a public company can appoint more than one proxy to attend the same meeting. But a member of a private company cannot appoint more than one proxy to attend the same meeting. A proxy may or may not be a member of the company. A proxy has no right to speak at a meeting, but he can demand a poll. Unless the articles of a company provide otherwise, a proxy cannot vote except on a poll. However, the articles of association of a company may also provide for the proxy's right to vote in voting by show of hands. A minor cannot be appointed as a proxy. Every notice convening a general meeting should state in a reasonably prominent manner that a member entitled to attend and vote at a meeting is entitled to appoint a proxy, and that the proxy so appointed need not necessarily be a member of the company. If a default is made in this regard, every officer of the company who is responsible for the default is liable to a fine which may extend up to rupees 500. The instrument appointing a proxy must be in writing, in proper form, and duly signed by the appointer or his authorized agent. The instrument appointing proxy must be duly stamped, and the stamp must be cancelled. It must be dated. Remaining provisions of the Companies Act relating to company meetings are discussed in the coming sessions. Thank you.